Hi, it's Anne-Marie from Charmed Live Therapy again. I don't know if this camera's blurry or my eyes are blurry, but something looks blurry. Please do hit that like and subscribe and share if you can and you're enjoying this content. I've been a bit quiet the last few days and I know a lot has been going on, but my head's been pretty full and I found a lot of it just a little bit depressing to go back into. Point in case the fact that Blake dropped a second amended complaint, midnight the day before she was due to be deposed. And it's funny, the last video I made, I'd forgotten all about mentioning that supposedly she wasn't going to attend this deposition, which was just as well because it would seem she did attend the deposition and something has just dropped on the docket to indicate that she did attend said deposition. So that's quite interesting. But yeah, the second amended complaint dropped and I kind of did a big groan. I mean, I kind of guess she had to. Well, she didn't have to. She didn't have to do any of this stuff. But if she wanted to keep Jed Wallace in her law complaint, then she had to. Forgive me for itching my nose. She kind of had to, I guess, if she wanted to keep him in. And if she chose not to keep him in, then she's the architect of her own downfall here because there's still the case going on in Texas that she's not got out of yet. Lively versus Wallace, Wallace versus Lively. There's still that. And plus, if she lets him out of this case in New York, she basically is definitely admitting there's nobody that was in charge of, that was the mastermind behind the untraceable, unsmearable, as I call it, the untraceable, unsmearable campaign. Because there's nothing you can say about this smear campaign that will prove it didn't happen in Blake Lively's eyes. So it's an unsmearable smear campaign. So anyway, I was going to break down the second amended complaint and just kind of go through it and highlight bits. Till I realised it was 149 pages, and I'll walk you through what I did do, which was like 2 or 3 pages, and there was that much that I highlighted that's kind of total hypocrisy that I thought, oh no, I don't think I'm going to get my way through the whole thing. But basically much of it is similar, apart from kind of like what some people have said. There's little bits and pieces here that are added, but they're redacted anyway, so they're no good to us right now. And this business of her saying that somehow, because she posted pictures of herself in New York during that early promo for It Ends With Us, and Jed Wallace was supposedly passively observing her social media at that time, then that somehow pulls him into New York jurisdiction, because no matter where he was in time and space, he could have been out with the Fantastic Four somewhere, and she would still say, well, you happen to be checking in on my Instagram when I was in New York, so that ties you to New York and I can penalise you under New York jurisdiction. I don't know. I don't pretend to know how that supposedly works. So anyway, I'm going to break down Kevin Fritz's latest email, because that's always a cheery thing to get a Kevin Fritz letter. And there's also the continued persecution going on of Breanna, Butler, Koslow and Katherine, or I think she might call herself Katie Case. These 2 poor women that have been hounded. I think one is a current member, current employee of the agency group, TAG, Melissa Nathan's company, and one's a former one. So they've just been put through the ringer by Blake Lively's team, whereby they had Blake Lively paid for their phones or devices or whatever it was to be forensically examined and to have everything extracted. And now Stephanie Jones, like just a day or so later, says, actually, I want this different stuff within 4 days, blah, blah, blah. And at this point, and don't forget Stephanie Jones is also still desperately trying to pretend that these women created these websites, these Stephanie Jones leaks websites, that I think there's a couple of different websites that are kind of like disparaging Stephanie Jones, and Stephanie Jones is still desperately trying to portray that these women have something to do with it, that they're masterminding that, even though she's had information back from her own. I mean, the digital forensics people are getting really rich off the back of this lawsuit, because everybody's been digitally forensically analysed. But it turns out that a former employee of Stephanie Jones is the one that set up stephaniejonesleaks.com. So you tell me why she's still pursuing and harassing these girls. So let's have just a brief look at the second amended complaint. And I only got like 3 pages, I think. And I thought, I have to stop correcting this because it's not working. So it's still that horrible paragraph at the beginning where she rips off Justin's own words. Are you confident enough to listen to the women in your life, to hear their ideas and their solutions, to hold their anguish and actually believe them, even if what they're saying is against you? And will you actually stand up and do something so that one day we don't have to live in a world where a woman has to risk everything and come forward to say the words, me too? And of course, we know that Blake Lively has risked everything. She's detonated herself doing this, and not in the way that she intended. So plaintiff Blake Lively brings this lawsuit because she was unlawfully retaliated against for coming forward and reporting sexual harassment that occurred against her and others on the set of It Ends With Us, the film. So we kind of know that she didn't officially report it in any sense, not properly, not following any kind of procedure. So how can she be retaliated against for coming forward and reporting sexual harassment? She didn't report sexual harassment until she went to the CRD, and then she refused the CRD's investigation that would have been linked to that. She could have had the EOC conduct an investigation at that point, and that would have made sense then if Justin had retaliated after that. But she's saying, still sticking to that, she was unlawfully retaliated against for coming forward and reporting sexual harassment. And it's this and others, isn't it? Against her and others. The others are still not speaking out, and it's still implied or said that these others will miraculously appear at trial if it ever comes to trial. But we still don't know who and others. I mean, and others sounds terrible, doesn't it? Because it basically sounds like every woman on that set was in danger. So Defendant Wayfarer Studios is the owner of the film. Defendant Justin Baldoni is the co-chairman and co-founder of Wayfarer, and also served as director, executive producer and actor in the lead role of Ryle in the film. Ms. Lively played the leading role of Lily Bloom. At all times during the production, editing and promotion of the film, Mr. Baldoni was Ms. Lively's boss. And you can actually hear the laughter across the universe at the idea that by any means was Justin Baldoni still Blake Lively's boss by the end of this, all during production, editing and promotion of the film, did kind of Justin decide as the boss to go in the basement? Did Justin decide as the boss to lock himself out of the editing studio and not have his version of the film be the one that was put on the market? For years prior, you can see why I didn't get very far with this amended complaint, can't you? We've not looked at this for a bit, so it kind of it is kind of useful, I guess, to go back with a bit of emotional distance, I guess, and look at it again. For years prior to the release of the film, Mr. Baldoni portrayed himself as a leader of the male feminist movement, writing books, hosting podcasts, holding TED Talks on the topic. In reality, however, Mr. Baldoni's public persona is a stark contrast to his private behaviour, which is replete with hypocrisy, misogyny and retaliation. In public, Mr. Baldoni gave the appearance of taking responsibility for the fact that he had unconsciously been hurting and silencing, and there's a lot of use of inverted commas, the women in his life, and implored men to be man enough to shut the hell up and listen to women. He claimed that he wanted to end toxic masculinity, acknowledging his own toxic behaviour by admitting, "There is a woman or two that I in some way made uncomfortable by saying something or doing something that was chauvinistic or sexist." And what pops into my mind is, hello, Ryan Reynolds and Olivia Wilde with the hands on her breasts and removing her pasties and putting your hands right back there, because that seemed like the best thing to do. Hello, Ryan Reynolds, ogling a breastfeeding mother in a hotel lobby. Hello, Ryan Reynolds, making his 7 or 8-year-old daughter say grotesque and sexually explicit things on a movie set with hundreds and hundreds of people stood watching her just to make it further more difficult. I think that's kind of toxic masculinity, misogyny, and a few other little bits and bobs there. There is 1,000,000% probability that that exists and that he wanted to say he was sorry and would do better. Mr. Baldoni echoed this narrative on marketing the film in an interview on CBS discussing the release of the film on August 7th. He claimed, "I want men to stop asking the question, why do women stay? I want men to take accountability. I want men to take accountability. I want men to hold other men accountable at his own moment of truth." And Jesus, doesn't it sound biblical? At his own moment of truth. You'd think he was in the Garden of Gethsemane. When forced to confront women he had made uncomfortable on his own set. What is uncomfortable? I'm uncomfortable every time I put somebody into hypnosis, I tell you, because I'm thinking, is this, I know I'm good at what I do, but there's always an element of unpredictability, and you don't know how each individual person has responded or how you're going to have to think on the fly. I'm damn uncomfortable every time I work, and so are a lot of men and women out there, and people of all kinds of races, sexualities, and proclivities and all the rest of it. We walk around all day, every day, being frigging uncomfortable as human beings. But anyway, Justin trivialised their concerns and failed to take accountability. And don't forget, they didn't seem to waste any time being accountable for Jenny Slate's $15,000 bill for an apartment that she chose that wasn't suitable or good enough for her. Jamie Heath seemed to step up pretty quick and take accountability for a debt that was not his, and then she blamed him for the language in which he made the offer. And they had to deal with that. There was a discussion, wasn't there, very early on the day of the set. There was some remark made that there's already something lodged in HR we have to deal with. So it sounded like they did take accountability for things straight away. So she's still saying he trivialised their concerns and failed to take accountability for the effects of his behaviour, whether intended or not. And that is the thing. I do think that Justin and Jamie and whoever else kind of was on that set that possibly was a member of the Baha'i faith, that loving, affectionate, all-encompassing thing would not be appreciated by Blake Lively. She doesn't know kindness or softness, not genuine kindness or softness that is non-judgmental and it isn't trying to straighten somebody's crown and just distract from them and make her the focus and all of that. She doesn't understand people using loving language and kind gestures and wanting to give hugs and things like that and start the day with a prayer or sage the set or anything like that. This is what we're talking about, isn't it, really, when they're saying uncomfortable, that it was these type of things. It wasn't SH that was making people uncomfortable. It was these well-meant gestures that weren't being taken very well. So, and when faced with the predictable consequences of having created a toxic set, I mean, if he was saging it, it shouldn't have been toxic at all, should it, really? Namely, that the cast did not want to appear alongside him in public. Now, after Blake Lively tainted them against him, a cast who had previously acknowledged what a wonderful working environment it had been working with Justin and what a good job he'd done at it. And Brendan's Glennar was one of the people that did that, and Isabella, Melissa said Isabella's Glennar. They've all got complicated names. Isabella Ferrer that sent him the lovely text saying how wonderful he'd made it for her and what a brilliant director he was and all of the rest of it. So rather than holding himself accountable for the way the cast shunned him in public, Mr. Baldoni hid behind his billionaire friend. Did Blake Lively not use her billionaire friend throughout the making of It Ends With Us and throughout the marketing and promotion of it, where Taylor Swift, her billionaire friend, one of her billionaire friends, was off doing the Eras tour and too busy to police what Blake Lively was saying about her on a minute-by-minute, hour-by-hour basis? Did not Blake Lively bring her billionaire friend into it too, just to create a kind of alibi? In a way, she used Taylor Swift as an alibi for some of her own actions. She got Taylor Swift's name in at every opportunity during that marketing and promotion, and it was an absolute power move. That's what that was all about, and it was to consistently remind Justin as well that he couldn't fight this narrative. So Mr. Baldoni hid behind his billionaire friend and retained publicists, crisis managers, digital media strategists, and litigators. Is he not supposed to have a lawyer when somebody's suing him? To mount a sophisticated and well-funded retaliation campaign. And this is the narrative now, isn't it? That Brian Friedman and Kevin Fritz and all the rest of them, these are perpetuating and elaborating on the original retaliation and defamation, I guess, that he somehow decided, Justin, that he was going to pay a lawyer to add to his army of digital unsmearable campaigns. And that's why she wants all the information from Brian Friedman's messages regarding communication with content creators, media people, and the rest of it. So, yeah, if you were going to create an untraceable smear campaign, the first thing you do would be to ask a lawyer to enact it for you, and a lawyer to not to litigate on your behalf or defend you, but to actually just continue a harassment of defamation against somebody and retaliation. So he hired a litigator to mount a sophisticated and well-funded retaliation campaign. Is not her campaign well-funded that sought to bury and destroy anyone that challenged his brand? That campaign has succeeded beyond Mr. Baldoni's wildest expectations. Not really. Because the first thing that came into mind is if it had succeeded beyond Justin Baldoni's wildest expectations, then Blake Lively would have effed off by now. Wouldn't be a problem. And she would actually be taking accountability for her actions if Justin Baldoni's wildest expectations had been foreseen. And it's interesting, isn't it, that he turned up for for Blake Lively's deposition. I don't know how common that is. It may be common for a defendant to show up for the plaintiff's deposition. I don't know. I'm not an expert on that. And I guess there was all kind of aspects to that. She'd have had to lie to his face and he could hear it for himself. And during breaks, I guess they can pass notes backwards and forwards, him and Brian, as to, things to go back and pick her up on. And a lot of it for Justin may have been, I need to hear this for myself to know that I wasn't going mad, but I wasn't going crazy, and I need to see if it's the same story or if it's changed again. And I think there'll have been a lot of why he went was about coming to terms with it in his own mind and making sense of it for himself, I think. I don't necessarily think it will be about trying to intimidate her or anything like that, because I think Justin is well versed in the idea that nothing intimidates Blake Lively, really, because nothing really gets through. It doesn't pierce anything. So I think by now he knows that you don't win. Even if he wins this case, he still won't win, because he won't ever change Blake Lively's mind or her opinion or anything like that. There'll be no winning in that sense. So in fact, the defendant's actions have created such a toxic climate of online vitriol against Ms. Lively, her family, other members of the cast and various fact witnesses, that all of the above have received disturbing threats. So all of her family, other members, which members of her family? Are we talking about just Robin, her mother, her dead father, who? Her children? You know, you can't just to me, you can't just say this stuff without proving it as well. And she goes on to say, one fact witness known to publicly support Ms. Lively recently received a written threat indicating that the witness's family would be essayed and K'd unless the witness agreed to make a statement and give the truth. This type of climate was the predictable, if not inevitable, result of the retaliatory campaign launched by the Baldoni Wayfarer parties both before and after litigation began. But she's just refusing to prove any of these things, and she says it's to do with protection. The dangerous climate of threats, harassment and intimidation fueled by the defendant's retaliation campaign has required Ms. Lively to alter her personal and professional life. Bollocks! Bollocks, what has changed? And to take steps to protect innocent bystanders. Bystanders! That's what they are, bystanders. Rather than exposing them to further harm. Thus, this amended complaint does not refer to certain witnesses by name. And that's because she's still trying to gather them up. I wonder if she's even still trying to gather them up. I suspect she was having trouble trying to gather them up the first time around, which is why there's no names and this bollocks about protecting people. Who has Blake Lively been protecting all along, with all the people whose names she's doxed and addresses doxed and emails doxed? She's not this person going around protecting people. So this business of I can't name anybody that could back me up because that would expose them to harassment and harm and the rest of it. And it's all interesting, isn't it? Because the content creators initially couldn't be anonymous to protect them, to protect themselves from harm or their families from harm. But Blake Lively can. Blake Lively can bring a lawsuit against somebody, say he did it to a whole bunch of other people too, and not have to name all of them till push comes to shove and there's a trial one day, if it ever comes to that. So, anyway, I don't know if I kept going after this, but you can see kind of why I stopped, really, because it was just making me annoyed, and it was just bringing it all up and thinking, yeah, but what about this, and what about that, and what about the other, and so I just gave up on it, really, because I thought, no, this is not going to get me or anybody else any further. But let's kind of have a look at the recent Kevin Fritz. I think it's Kevin Fritz. Yes, it is. It's Kevin Fritz letter. So this was dated yesterday. And there's a bit of redaction because it contains information from the deposition. So, dear Judge Lyman, as counsel for Wayfarer Studios LLC, Justin Baldoni, collectively the Wayfarer parties, and for Liner Friedman, Tattleman and Cooley LLP, we write in response to Blake Lively's letter, docket 533, concerning Liner Friedman's motion to quash the subpoena that she served upon the law firm. The motion. To justify the harassing subpoena, the letter erroneously alleges that Brian Friedman Esquire defamed Lively and that his conduct had amounted to public relations work rather than that of an attorney. It appears that Lively is slowly realising that there is no retaliatory smear campaign by the Wayfarer parties against her. Consequently, Lively is shifting her focus to Liner Friedman in connection with her 14th cause of action, which alleges that certain Wayfarer parties, through their attorney Friedman, through his inverted comments, purportedly defamed her via post-litigation statements to the media. Upon questioning by Friedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves blacked out track. Counterclaims filed without. So then it cites some Exhibit A, I think, something, and a quotation of it. Counterclaims filed without retaliatory motive and with a reasonable basis in fact and law, such as the claims filed by the Wayfarer parties against Lively, do not constitute an adverse employment action within the meaning of anti-discrimination statutes. And then there's some of Judge Lyman's case law cited. Moreover, statements by the Wayfarer parties to the media directly or through their counsel defending themselves against Lively's bogus claims of harassment do not qualify as retaliatory conduct, more case law of Judge Lyman's quoted. As for the 14th cause of action for defamation, New York law provides an absolute privilege for communications made by individuals participating in a public function such as executive, legislative, judicial, or quasi-judicial proceedings. More case law quoted. The privilege is accorded statements made at all stages of a judicial proceeding in communications among the parties, witnesses, counsel, and the court, provided that the statements may be considered in some way pertinent to the issue in the proceeding. And then more case law is cited, which kind of goes to the privilege applies to all statements made in or out of court and regardless of the motive for which they were made. So even if they were meant to be harmful, it doesn't matter. In short, Lively is aggressively pursuing discovery for a defamation claim that will surely be dismissed upon a dispositive motion. In any event, Lively does not adequately address the court's inquiry. Oh, it said that American then. We would have said inquiry concerning the undue burden imposed upon Lina Friedman by the subpoena. According to Lively, the subpoena is not unduly burdensome because on December 23, 2024, days after Lively caused her allegations in her CRD rights complaint to be widely disseminated by the New York Times, her counsel demanded that Lina Friedman cease and desist from, in essence, publicly responding thereto on behalf of the Wayfarer party. So yeah, you're not allowed to talk about me negatively, which is the whole friggin' problem right from the start. All of those agreements she wanted people agreed to or twisted their arm to agree to. It was all about, you can't look at me funny, you can't say anything funny, you can't talk behind my back, you can't do this, you can't defend yourself. And if I hear you've done any of those things, I'm going to have you. That's basically what it was, isn't it, really? So her counsel demanded that Lina Friedman cease and desist from, in essence, publicly responding thereto on behalf of the Wayfarer parties. Therefore, according to Lively, Lina Friedman has known for more than 6 months that she may seek discovery from the law firm. However, at the hearing on the motion, the court astutely asked Lively's counsel why discovery was needed from Lina Friedman via the subpoena in connection with the defamation claim if Lively knows which statements are at issue. Lively had no viable response at the hearing and does not offer one now. Indeed, the second amended complaint not only identifies the specific statements by Friedman that Lively contends were defamatory, but also conveniently provides link to the publications. In brief, Lively knows to whom the statements at issue were made, hence they're still not untraceable, they're not sneaky or underhanded. So, in brief, Lively knows to whom the statements at issue were made, where they were published and when, which renders the subpoena unnecessary and unduly burdensome. The motion should be granted, and this case law cited, Judge Lyman's again, which was granting motion to quash subpoena to non-party attorney representing defendant because the subpoena risked implication of privileged attorney work product. The documents sought were of marginal relevance and plaintiff failed to demonstrate the information sought could not be obtained from another source. So that was the case law quoted in support of that. So I think much of that was to do with Brian's interview with Megyn Kelly. I think that was the main thing that was at fault there. So yeah, it always cheers you up, I think, when you get a letter from Kevin Fritz. He does do it quite well. So if you're still with me, we'll just kind of quickly look at the letter from Prior Cashman LLP, who are responding on behalf of the non-parties, Katherine Case and Breanna Butler, who are being tortured left, right and centre by this thing. So this is like, they've just been put through the mill to give information to Blake Lively. And actually they're quite nice about Blake Lively in this letter, because they acknowledge that Blake Lively paid for it, kind of found the company, blah-de-blah, you know, so that it was relatively painless. But now they're being pursued by Stephanie Jones. And there's recently been an agreement, hasn't there, that all parties are going to share these things. So anything produced is not having to be produced multiple times. The sharing it results of discovery and things where it's applicable. So dear Judge Lyman, non-parties Katherine Case and Breanna Butler Koslow respectfully submit this response to the motion to compel filed by Stephanie Jones and Jones Works LLC. Introduction. The Jones parties request that Ms. Case and Ms. Butler Koslow, non-parties associated with the agency group LLC, re-review and produce materials in response to their subpoenas, notwithstanding that for 4 months the Jones parties sat idly, knowing that Ms. Case and Ms. Butler Koslow objected to the subpoenas due to the overbreadth of the requests and the burden compliance would entail, and negotiated and produced materials in response to subpoenas served by Ms. Lively in the Lively action. Had the Jones parties pursued their subpoenas, Ms. Case and Ms. Butler Koslow could have reviewed materials in response to both sets of subpoenas at once. Instead, after months of intentional neglect, the Jones parties demand starting the document review and production process anew. In doing so, the Jones parties conceal their 4-month neglect of their subpoenas, evidently hoping that both their neglect and their concealment of it will go unnoticed by the court, because this prejudicial conduct violates both the spirit and letter of Rule 45. The Jones parties' motion should be denied, the subpoenas should be quashed, and an award of costs should be considered. Nobody's paying much attention to the amount of people at this point asking for costs that have been incurred in dealing with all of these things. Background. On February 17th, the Jones parties propounded document subpoenas on Ms. Case and Ms. Butler Koslow. On March 10th, Ms. Case and, her name's too long, Ms. Koslow, provided the Jones parties with their responses and objections. On March 21, we met and conferred with counsel for the Jones parties. We stated that although our clients were willing to produce responsive documents, the requests as served were overbroad and would impose an undue burden on non-parties. We requested that the subpoenas be withdrawn and reissued with considerably narrowed requests. The Jones parties do not mention any of this. In this same period, we met and conferred with counsel for Ms. Lively in connection with her subpoenas. Through that process, Ms. Case and Ms. Butler Koslow requested and received concessions from Ms. Lively's counsel. So that's, acknowledging that, isn't it? Including narrowing and cost shifting. So Blake paid for it, basically. Although negotiations broke down over an appropriate date range, resulting in motion practice before Your Honour, Ms. Lively paid for Ms. Case and Ms. Butler Koslow's costs, and the parties negotiated review scope and process. Production of all materials responsive to Ms. Lively's request was completed on July 20th. The Jones parties did none of this. And Stephanie Jones doesn't even think she has to sit for a deposition, does she? So this is not surprising, really. So the Jones parties failed to raise their subpoenas despite conducting conferences on other issues, and there's Exhibit B to prove that, waited until Ms. Case and Ms. Koslow had completed their productions to Ms. Lively, and then, the day after those productions were complete, July 21st, demanded compliance with their subpoenas within 4 days. On July 22, we advised that given the prejudice caused by the delay, we would not produce materials in response to the subpoenas as propounded. On July 23, the Jones parties preferred minor limitations. On July 29th, we conferred with the Jones parties and stated that the subpoenas were still overbroad, requested that the requests be further narrowed, and offered to produce the materials produced to Ms. Lively. We further advised that if the Jones parties stood on their requests, a motion to quash would follow. Counsel represented that they would respond to our request and proposal. Instead of doing so, they filed the motion at docket 89. In their motion, the Jones parties misrepresent multiple details. First, the Jones parties omit their months of inaction that occurred despite knowing that Ms. Case and Koslow were actively engaging with Ms. Lively about her subpoenas. The Jones parties evidently stalled prosecution of their subpoenas to secure a strategic advantage by first reviewing what was produced to Ms. Lively. Very sneaky. Second, the Jones parties claim that Ms. Case and Koslow refused to produce any documents in response to the subpoenas at docket 89 is an outright misrepresentation, as the Jones parties themselves stated in a July 30th email. While you are amenable to providing us the documents produced in the Lively action as well as the search terms you used, you are not amenable to producing additional documents responsive to our subpoenas. Do you remember those search terms were really broad that Blake asked for in those productions, and it related to Ryan and all kinds of things. It was a really long list of search terms. So they were offered a heck of a lot of information, these people. I'm not sure what they expect to find besides those search terms. So third, contrary to the Jones parties' assertions, Ms. Case and Koslow explained how the Jones parties delayed prosecution of their subpoenas, imposed additional burden and caused undue prejudice. Compliance requires, at a minimum, renegotiation of search terms, re-engagement of a vendor, rehiring and retraining a review team, and re-review of materials. That's insane, isn't it? The court should deny the motion, the Jones parties' months of inaction, because really the Jones parties have not wanted to take action all along because they've kept hoping to be dismissed out of this thing. They haven't been doing anything, only to demand duplicative review and production now, which is improper. Rule 26b(1) requires that discovery not only be relevant but also proportionate. Rule 45 imposes an affirmative duty on the subpoenaing party to take reasonable steps to avoid imposing undue burden or expense when the subpoena is issued to a non-party. Courts routinely quash or limit subpoenas that lack reasonable specificity or demand the production of documents not tailored to the issues in the underlying litigation. Again, it's like there's a real similarity between Stephanie Jones and Blake Lively, in the way that neither wants to accept that the things that have happened to them are because of things that they did or said. Stephanie Jones doesn't want to believe that this Stephanie Jones Leaks website and other ones like it came into being because people didn't like the way that she was treating them. There's a very similar thread running between Blake and Stephanie Jones, really, isn't there? They're alike in many ways. So then there's a lot of case law quoted, basically about some of which was quashing non-party subpoena that demanded all documents. So the subpoenas, both as propounded on these ladies and as narrowed, are facially overbroad. They request all documents across a range of topics without meaningful limitation as to time, subject matter or relevance. Paradoxically, the narrowed subpoenas contain more requests than the originals and do not limit their scope. Dilatory and duplicative discovery that is available from other parties or through less intrusive means like that sought by the Jones parties is unduly burdensome. More case law is quoted, where a case got pushed back when they were demanding compliance within 4 days of notice and emphasising that the issuing party had no excuse for waiting until the 11th hour. And another piece of case law there about a requesting party failed to take any reasonable steps to obtain the information sought through other means. So the Jones party's strategic delay and failure to confer only to demand re-review of personal documents on an impossible timeline is improper, sharp practice, and is precisely the conduct Rule 45D1 was designed to prevent their failure to engage in a timely and good faith meet and confer process is sufficient grounds to deny a motion to compel alone. More case law cited, which basically what came out of that was failure to meet and confer in good faith is sufficient reason by itself to deny plaintiff's motion to compel, and more case law. So for the reasons set forth above, the Jones party's strategic delay and gamesmanship, the burdensome and duplicative nature of the subpoenas, and the avoidable prejudice the Jones parties seek to impose on Ms. Case and Ms. Koslow, we respectfully request that the court deny the Jones party's motion to compel and quash the subpoenas in their entirety. We further request the costs be awarded under Rule 45 and the court's inherent authority, given the Jones party's misstatements to the court and their strategic and improper attempt to weaponise delay. So that's kind of what's going on in the background as well, apart and separate from Blake. And I guess maybe you've probably been keeping up with Perez too, and what he's been up to in Las Vegas. I caught one of his videos the other day, and it kind of had a lot of fun emailing Ezra Hudson, I believe, and copying her in on his motion protective order and motion to quash. And it kind of got in there some of his Blake Lively slurs. It got in there the 0-time Oscar-nominated client of theirs, Blake Lively. I think he'd had a great deal of fun emailing them and had actually copied the judge in on it as well. But what was funny was that I don't know if you'd heard it, that his original protective order that he requested, he'd used ChatGPT, which I'm guilty of at times. But what I didn't know was that ChatGPT came up with some hallucinatory cases for his motion for his protective order. So he basically cited this case law that ChatGPT had made up or hallucinated, or somebody had hallucinated somewhere else, and ChatGPT had found it useful and presented it to Perez to use in his protective order. And it's kind of just symptomatic, isn't it, of where we're at with it all, really. But yeah, I would have loved to have been a fly on the wall for the deposition as to the manner in which she conducted it. It's like I was thinking today, would she have gone in kind of as a victim? Would she have gone in on the offensive? Would she have gone in wearing her female advocate for women and girls? Which Blake showed up for deposition, I wondered, and wonder how Justin felt sat there looking at her, and I'm just wondering, did she have a briefcase with her? Like I thought she'd have bought, a nice new Louis Vuitton briefcase or something like that. Or did she go in casual? Did she go in all dressy? It would have been interesting to know which version of Blake showed up, whether it was a victim, whether it was somebody that was just in victim mode, whether she turned up as the aggressor, or whether she was a mixture of all of those. But even just that little snippet from Kevin that came through was very, very interesting, because even that, and we don't know the words that she said, it kind of says that even she could not specify specific incidents. So it's like, you kind of, even in that little snapshot, you kind of get this idea that maybe is she falling apart? Maybe is she really grounding to a halt? I mean, obviously, this is the defence, and they'll spin it whichever way works for them when they're writing to the judge. But So that little piece again was, upon questioning by Friedman at her recent deposition, Lively admitted that the only ongoing smear campaign about which she has personal knowledge involves, and it's redacted. So that's basically her admitting that she's still reliant on everybody else to come up with a smear campaign. She still thinks there is one, but she has no personal knowledge of one other than what she believes Lina Friedman is doing. But it's all this information and belief thing, isn't it? It's not real. There's nothing tangible that she can get hold of. So even just that little snippet, it kind of gives us an insight that maybe it didn't go so well for her, the deposition, and that maybe we've got some hope. You know, I think we still get that feeling that there's much going on in the background that Lina Friedman and Kevin Fritz and all of the rest of it can't say just yet, but that possibly it will be this summary judgment business, and that this may not go to trial because bit by bit is she just losing her case? Is there just nothing there? The more she tries to prove it, the more it falls apart, and the more desperate looking she gets, the more that becomes self-evident. And there's all this to be decided yet, to do with all these motions to quash that are in, or people saying we want sanctions here, we want costs here. Is the judge going to just, because Ezra Hudson isn't responding to them at this point in time, they're ignoring these letters and these motions, but is the judge going to ignore them? Can they do that? Can the judge and Ezra Hudson ignore these very real people with very real claims for damages and annoyance and the frustration, and that sanctions, even if it's just a sanction in words, would be something, and don't do this again, you've had it now, that's enough. Will it be addressed? So anyway, I hope that was a little bit useful to you and interesting to watch on a Saturday. Please do hit that like and subscribe and share and let me know your own thoughts, and I will see you again soon. Bye bye.